President.
Senator from Maine.
Mr. President, first I want to congratulate and thank the senator from Rhode Island for his moving and eloquent remarks. So moving and eloquent, in fact, that I've contemplated foregoing my own. The senator expressed the feelings of many of us, particularly in his peroration, which was very powerful and I think very well encapsulated the one possible positive result from this sorry process. Mr. President, I stated my opposition to Brett Kavanaugh's appointment to the United States Supreme Court before Dr. Ford's allegations became public, before I had ever heard about them, before anyone had heard about them, as far as I know, except some members of the Judiciary Committee. Therefore, I don't believe you have to believe Dr. Ford to conclude that Judge Kavanaugh should not be elevated to the Supreme Court. First, because of his judicial philosophy. And if you'll pardon me, I want to digress for a moment into constitutional history, pre-constitutional history, if you will. There's a basic paradox of government. We give power to something called the government in order to protect our security, to protect us as individuals, to protect our liberty. The paradox is that we then have to worry about the government to which we've given the power abusing us. James Madison captured this in the 51st Federalist. If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, and of course today Madison would say men and women over men and women, in framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. The Romans put it this way: quis custodies ipso custodes? Who will guard the guardians? The other philosopher that talked about this was the English philosopher Lord Acton. All power corrupts, and absolute power corrupts absolutely. The American Constitution, in my view, is the most sublime answer to this ancient question of any instrument of government ever formed by people on this earth. It's based upon a profound understanding of human nature. That if you give people power, there's the potential for it to be abused. Not the potential, the likelihood that it will be abused. So the Constitution is an elaborate scheme for preventing that abuse. The first line of defense is the structure of the government itself. What Madison was talking about, obliging the government to control itself. This herky-jerky, complicated Rube Goldberg device involving two houses, checks and balances, the president, the veto, submitting treaties, two-thirds votes, advise and consent, and then the whole level of the state government and local government and the division of responsibilities between the government, enumerated powers. The framers wanted it to be difficult for majorities to ride roughshod over minorities. They wanted it to be difficult to legislate, and they succeeded beyond their wildest dreams. It is a very difficult piece of machinery to bring into action. But even after the framers had designed this elaborate structure specifically in the name of protecting the rights of the people, they weren't satisfied. They wanted to take another step, because going back to our other fundamental document, the Declaration of Independence, which talks about certain inalienable rights, life, liberty, and the pursuit of happiness. And that word inalienable isn't defined much. Not much attention is paid to it. But what inalienable means, you can neither give it away nor can it be taken from you. To alienate is to give away or to have it taken from you. That's what inalienable rights mean. So going back to that, they said, we've got this elaborate structure that's going to be very complicated to operate, but what if the majority makes this structure work in such a way that's inimical to the fundamental rights of the people? So the first thing the first Congress did was adopt the Bill of Rights. And the Bill of Rights is the second shield for us as individuals. I've always thought of it as a force field around individuals that protects the basic rights, even if the government follows all the procedures. Congress shall make no law abridging the freedom of speech, establishing religion, or controlling the free exercise thereof. Search and seizure must be reasonable. You don't have to give testimony against yourself. All of these rights in the Bill of Rights are designed to protect us as individuals from the government. Now, the framers then had an interesting problem when they got to the Bill of Rights and they listed the rights. Somebody, and I can't remember who it was right now, came up with the problem that if you list the rights, then people will later say, well, those rights are listed, therefore there aren't any other rights that can be protected. So they added the Ninth Amendment, which is one of the most unappreciated and undiscussed amendments to the Constitution. The Ninth Amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In other words, there are rights that exist, they recognize that aren't the ones listed that we all think of in the First through the Fifth Amendment. Rights such as freedom of speech, the press, freedom from unreasonable searches, the right to bear arms. They were afraid they would appear to exclude, so they passed, as part of the Bill of Rights, the Ninth Amendment. What does this have to do with Judge Kavanaugh? To understand Judge Kavanaugh's jurisprudence, what kind of judge he will be, and by the way, that's what we're all doing here. This is an exercise in forecasting the future. What will this person decide? What kind of judge will they be? And that involves things like demeanor and temperament, but it also involves judicial philosophy. To understand the judicial philosophy of Judge Kavanaugh, you have to understand the judicial philosophy of Justice William Rehnquist. Judge Kavanaugh has characterized Justice Rehnquist as his judicial hero. He gave a speech about him in 2017. He says that the article in the Texas Law Review in 1976 written by Justice Rehnquist is one of the most important legal documents ever written. So what does Justice Rehnquist and Justice Kavanaugh have in common? They have a very expansive view of what states can do to limit your rights and a narrow view of what the federal government can do to protect your health, welfare, the environment, you name it. Justice Rehnquist voted against Roe versus Wade. Justice Rehnquist criticized Griswold versus Connecticut. He voted against Roe versus Wade because he said, that's not an enumerated, the right of a woman to control her own reproductive health is not enumerated in the Constitution. Obviously, it's not listed in the first 2 or 3 amendments. But the court found that it was a basic human right of women, and that's the basis of Roe versus Wade. The problem with Justice Rehnquist's approach and Justice Kavanaugh's approach to unenumerated rights is they say that unenumerated rights could be recognized by the courts only if the asserted right was rooted in the nation's history and tradition. That's called originalism, or at least it's a piece of originalism. In other words, you can't assert a right unless you can show that the framers thought about it when they passed the amendments, or that it was somehow rooted in the tradition. And if abortion was legal across the country in 1897 or 1867 or 1787, then you couldn't do it. The court would be making law. The problem is that approach freezes rights in history, and it allows no room for the evolution of ethics and morality. A good example is Loving versus Virginia, which was the case that overturned miscegenation laws, laws which made it illegal in many states in the country, including Virginia at the time, and this was in the 60s, made it illegal for people of different races to marry one another. Now, it's hard to argue using the Kavanaugh philosophy that that is a legitimate exercise of judicial authority, because certainly at the time of the passage of the Bill of Rights and the passage of the 14th Amendment, anti-miscegenation laws were all over the place. So Rehnquist and Kavanaugh would say you can't do that. And this isn't judicial lawmaking, this is judicial protection of individual rights from state incursion. Griswold versus Connecticut. In many ways, Griswold and some of the later cases, Griswold was the one that was a case that said the state of Connecticut could not constitutionally prohibit the sale of contraceptions to married couples. And it's been widely criticized. In many ways, the Griswold case, I believe, was the founding document of the Federalist Society. It was in reaction to Griswold and the following cases that the Federalist Society arose in the 1980s. So this philosophy is that the states have wide latitude to restrict these rights, enumerated or not. And that's why I believe there's, 50-50 chance, 60-40, 70-30, that a Justice Kavanaugh would repeal Roe versus Wade. I give it 99% that he will gut Roe versus Wade. There are something like 15 cases headed for the Supreme Court right now from various states around the country where the right of a woman to control her reproductive future is under assault, and the decisions may not be an outright repeal, but by piecemeal chipping away at that right, making it harder and harder to exercise, Roe versus Wade will be a hollow shell. Now, Judge Kavanaugh said in his hearing, I'm not going to make these value judgments, ideological judgments. I'm going to call balls and strikes like an umpire. Mr. President, I have a new principle for judging Supreme Court nominees. Anybody who says all they're going to do is call balls and strikes is an automatic no, because they're conning us. Deciding whether a particular rule in a state which restricts the ability of a woman to control her reproductive future is unduly burdensome is not a mechanical ball and strike. It's a value-laden judgment call. So don't tell me that there's some easy ball and strike thing here. You're making judgment calls based upon values. And I don't have any doubt that a Justice Kavanaugh is going to vote to restrict, to control, to limit, and ultimately to gut Roe versus Wade. Indeed, that's what the president said he was going to do, is appoint a judge who was going to take that step. That's why he's so widely supported in some parts of the country. And by the way, he said it's a precedent. Roe versus Wade is a precedent. That's like saying this is a chair. That's a statement of fact. That's not a value, that's not a philosophy, that's just a statement of fact. And then he says, well, we have Planned Parenthood versus Casey, so we have a precedent on a precedent. That's like saying this is a chair and this is a desk. That's a statement of fact. That is not anything that gives you any indication of what he says he's going to do. And by the way, Justice Gorsuch sat in my office and talked to me about precedent and how committed he was to precedent. He'd written a whole book about precedent. And I don't think he was on the court even a year, and he voted in the Janus case to absolutely trample 40 years of precedent in a very important area of American law. So when somebody tells me it's a precedent or it's settled law, that doesn't convince me of very much. That's not a predictor of what they will do. He has an expansive view of the state power to restrict individual rights. He has a narrow view of the national legislature's ability to protect individuals, whether it's health care. I'll give you 75% that he's going to start voting to undercut and destroy the Affordable Care Act. On the environment, in 16 out of 18 cases on the environment that came before his court, the D.C. Court of Appeals, 16 out of 18, he voted with the polluters. Narrowed the authority of the Environmental Protection Agency. In one case, particularly relevant to my state, he decided against the right of the EPA to tell upwind states that they had to control their pollution in order to benefit downwind states. Maine is in the tailpipe of the Northeast. All the air moves from west to east and ends up in Maine. We could shut off every automobile and every factory in Maine and still have air pollution problems. So telling the EPA they can't regulate air that moves across state lines is a direct shot at the state of Maine. Campaign finance reform. I predict he'll join with the 5-4 majority to continue the deregulation of campaign finance, one of the most serious issues facing this country. He even said that net neutrality was unconstitutional because of the right of large internet service providers to have free press, free speech. That's a case that would deny free speech and freedom of activity to millions of internet users across the country. You don't have to believe Dr. Ford to oppose and believe that Brett Kavanaugh should not be elevated to the Supreme Court. You also don't have to believe Dr. Ford to believe that Brett Kavanaugh should not be elevated to the Supreme Court because of his views on presidential power. Not necessarily his views on presidential power, but first let's establish what he said. In the Minnesota Law Review, he said, "We should not burden a sitting president with civil suits, criminal investigations, or criminal prosecutions." He has an elaborate argument about that involving impeachment and that the Congress should pass a statute and a whole lot of things. We can argue about that. There are legitimate disputes about the meaning of Article 3 and how it relates to impeachment and how it relates to the subject of the president being subject to criminal prosecutions. I understand that. I understand we can have those arguments. But once he stated that position, he should have announced that he would recuse himself from any case involving the president who appointed him. The first rule of the judicial canons, canon number 2, is a judge shall avoid not only impropriety, but the appearance of impropriety. The appearance of impropriety. And 2A, this is the Code of Judicial Responsibility, a judge should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Let me read that again. The judge should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. The reason for that is obvious. The judiciary doesn't have the power of the purse. It doesn't have an army. It's got to rest upon public confidence. He already violated that principle in his testimony to the Judiciary Committee last week. He violated that principle. Imagine the reaction of the public if a newly minted Justice Kavanaugh within the next couple of years votes in favor, indeed could provide the deciding vote, the swing vote, on a case involving the president who appointed him. I'm not saying he can't take this position ever in his judicial career, but to have not recused himself, and he had an opportunity to do so, to announce that he would do so, to me is disqualifying. It's obvious and mandatory that he should not take a position on a case coming before the court involving the president who appointed him. Number three, we don't have to believe Dr. Ford to conclude that Judge Kavanaugh should not be confirmed to a lifetime job because we've been denied the ability to learn about his record. Imagine, Mr. President, you're doing a job interview for a very important job in your company. And a guy comes in and says, I'd like this job, and I'm going to show you 10% of my work product, and the 10% that I'm going to give you is going to be picked out by an old buddy of mine that I used to work for. In fact, he used to work for me. Oh, and by the way, once you hire me, you can never fire me. I'm there for life. Nobody would take that deal. Any employer in America would laugh at that job applicant, and yet that's exactly what we're doing here this week. We've seen 10% of his record in the White House, and given no reason whatsoever why we can't see it all. And people talk about, oh, we've seen 100,000 pages or 200,000 pages. That's not the point. He's got a huge record, so the number of pages isn't the issue. It's how much of it have we seen as a percentage, and we've seen 10% of it. If I were on the side of this case preparing to vote for this gentleman, I'd be terrified about what's going to come out, because it's all going to come out. The records of the Bush administration are going to be available in 2020 under the Presidential Records Act, 12 years from the end of the administration, 2020. All of these records are going to come out. In fact, I think they're going to start coming out in the next couple of weeks from the National Archives. I don't know what's in those records. There may be nothing. But the fact that they're being withheld raises my main suspicions. What are they? Are they worried that something's in there that will derail this nomination, or do they know it? And for asking us to vote on this lifetime appointment with no do-overs, no amendments, no chances, no repeals, when we haven't seen the entire record, is just, it's beyond me. There's no justification for it. As I say, if I were inclined, even if I was inclined to vote yes, I'd say, wait a minute, you can't ask me to vote for this until I see all his record. And we haven't done it. It's ridiculous. There's no other word for it. Number four, we don't have to believe Dr. Ford to conclude that Judge Kavanaugh should not be elevated to the Supreme Court because he has demonstrated that he lacks the temperament and demeanor to be a justice of the Supreme Court. Now, first, I think it's only fair to state the standard. What should the standard for temperament and demeanor for a judge be? Here's the standard as I have seen it. To be a good judge and a good umpire, it's important to have the proper demeanor. Really important, I think, to walk in the other's shoes, whether it be the other litigants, the litigants in the case, the other judges, to understand them, to keep our emotions in check, to keep our emotions in check, to be calm amidst the storm. On the bench, to put it in the vernacular, don't be a jerk. To show, this isn't me, this is a standard published, to show and help display that you are trying to make the decision impartially and dispassionately, based on the law and not based on your emotions. Who established that standard? Who wrote it? Brett Kavanaugh. Those are his words in a speech several years ago at Catholic University. Proper demeanor. Calm amidst the storm. On the bench, don't be a jerk. Help display you're trying to make decisions impartially and dispassionately based on the law and not based on your emotion. I don't see how anybody with a straight face can argue that Brett Kavanaugh met that standard last Thursday afternoon. I had an interesting experience that day. I was in a hearing in the afternoon while he was speaking, and there was a television screen in the hearing room, but the sound was off because we were doing other committee work. But every now and then you could look at the screen, I could see him. And I turned to the person sitting behind me and said, "He's coming unhinged. What's going on? What's he saying?" He's shouting. You could see it. You could see his face contorted. And then, of course, I saw what he was saying. No one could argue that he demonstrated judicial demeanor in that hearing. And in fact, something like 3,000 law professors, including 40 from Yale, have come out and said, based on that performance, he should not be confirmed to the Supreme Court. Justice Stevens, John Paul Stevens, retired justice, extraordinary moment, said this man should not be confirmed for the Supreme Court. If you were from Mars, Mr. President, or from South Dakota, and you knew nothing about the history of this matter, you knew nothing about the documents, the opinions, the philosophy, none of those things. You knew nothing about those things. All you saw was that hearing that afternoon. You'd say, this guy has no business anywhere near a courtroom. Now, his defense is, I was angry. I was being charged with something. My family was being threatened, and I'm being threatened. And I understand that. All of us have thought about how we would feel if some unjust or untrue charge was made against us, whatever the nature, and a particularly heinous charge is made against him. I understand that he was passionate. But here's what really bothers me. What he said, the conspiracy, the direct insults to the Democratic senators, the idea that he was a victim of a smear and a smear campaign, he'd written down. That wasn't a spontaneous outburst. He was, so mad and caught up in the moment and said something he regretted. It was in his written testimony. He'd written it down. His answers to the questions. Back to canon number 2, avoid anything that would undermine confidence in the judiciary. He actually said, looking at the Democrats, what goes around comes around. Everybody knows that's a threat. And he's looking at Richard Blumenthal, who's the plaintiff in a case called Blumenthal versus Trump, which is in the federal district court in Washington and will eventually make its way to the Supreme Court based on the emoluments clause. How can Richard Blumenthal possibly believe he would get a fair and impartial hearing from somebody who said, what goes around comes around? That phrase itself should be disqualifying. Anybody who talks about a political party or a group of people or millions of people or anybody else and says what goes around comes around, that's disqualifying. So I think based upon judicial philosophy, his failure to recuse himself from issues involving the president who appointed him, his refusal to say that he will recuse himself in issues involving the president who appointed him, the incredible lack of documentation based upon his record and his demeanor last week disqualifies him. No, Mr. President, you don't have to believe Dr. Ford to conclude, as I have, that Judge Kavanaugh should not be elevated to the Supreme Court. But, Mr. President, before I close, I should add one note. I do believe Dr. Ford. Thank you, Mr. President. I yield the floor.